Good afternoon. I'm James Vann with Vann Attorneys here in North Carolina. We are so glad that you have dialed in and that you are participating with our webinar today. We're going to be talking about North Carolina lien law and how it's not necessarily changed as much as it is. We're going to review some of the changes over the last 4 or 5 years. A couple of cases that have come out. There's a new piece of legislation that has to do with the lien agent statute. And we really would love to hear from you. If you have questions, you may submit them one of two ways. You can either do it on your control panel on the GoToWebinar screen, or you can send it by email to webinar@vannattorneys.com. And a little housekeeping, if you want to go ahead and put it on your calendar, we're going to have another webinar on November 16th at 3 p.m. And we're going to be talking about what terms and conditions apply to your e-commerce contract. You say, well, I don't have an e-commerce contract, James. Yes, you do. If you use email, if you have customers that buy online, if you have customers that submit orders either any way of electronically, that's going to be a e-commerce or electronic commerce contract. So, again, we hope you will participate and go ahead and mark your calendar for that. So, thank you again for participating today. I want to say a special thank you also to Michael Fernald. Michael is working in our office, has worked in our office for, I think, 6 years. Michael is an incredibly smart young man. He also has a company called Technology Media, and he helps a wide variety of other companies with their technology issues, their marketing, just a whole host of things. But he helps us with these webinars, and he makes them look nice. So thank you very much, Michael, for that. So you can see a couple things we're going to be looking at today for the follow-up topics. Lien law effective 2016, we'll be looking at the changes that were made earlier, notice of contracts, why it's still important, and we may be able to hit some payment bond issues possibly down the road. So many of you know, in North Carolina lien law, giving notice is pretty much the key part of preserving your rights in lien law. Overview of the changes that have been made recently. Back in 2013, they started talking about wanting to have a lien agent to give a pre-notice to. There's an online way of doing that. Many of you use the liensnc.com website. If you haven't become familiar with that, we would suggest you look at the website, go ahead and sign up with them so that you can use their services. And if you have any questions, I'll be glad to help you with that. But that statute having to do with the creation of the lien law and the lien agent created some definitions, which is really a great way to start looking at. An owner, obviously, it's a person who has an interest in the property, typically who had a contract to improve the property. The contractor is whoever dealt with the owner. And then you've got your first, second, and third tier subcontractors, again, which, as you well know, they sort of go hand in hand going back up the tier process. So the lien agent is someone that has been appointed, and typically it's a title insurance company or agency designated by the owner to accept or receive any notices to the lien agent. In the statute, they said, who is an obligor? That's sort of a term, it's an unusual term that we don't use every single day, but that's either an owner, contractor, or sub in any tier that owes money to another. Having to do with the project. So again, an obligor could be a second tier where it owes money to the third, could be a first tier that owes it to the second, and so forth. So that's whoever an obligor is. These changes obviously affect private projects where the contract for the construction, initial contract, is $30,000 or more at the time that the building permit is issued. And if there's not a permit, then at the time there's been a contract between the owner and a contractor to improve the real property. There are a couple of exceptions, and that is where the cost of the improvement to the time of the original building permit is issued is less than $30,000. Let's say, for example, that I'm just going to say that they're doing a sidewalk and it's a $20,000 sidewalk. Well, there wouldn't be a need to have a lien agent appointed for that. But let's say they're going to do a sidewalk, driveway, and back porch, and it's $35,000. Well, there you go. That needs to be probably going to have a permit that also then requires a lien agent. Also, there's an exception that the lien agent is appointed is not mandatory. It's permissible but not mandatory if it's a single-family residential dwelling that's the owner's, it's supposed to be for the owner's primary residence. Say, for example, I'm going to build a house and I'm doing, I'm not going to be the contractor, but I'm going to do that myself. I'm starting the project. I'm going to be a very involved owner, and it's going to be for me. I'm going to hire someone to help do the work. In that case, that could be an exception where we wouldn't have to have a lien agent appointed. So that's just a few. I think for the most part, we get calls a lot from many of you that say, hey, look, I can't find a notice of the lien agent on the website. Can you help me find it? And we a lot of times look, and again, it's not that we're that much smarter than you guys by any means, but it's more or less a second set of eyes and thinking about it differently, looking at it. We're going to go through some tips and tricks in finding the lien agent notice on that website later on today. So what if the lien agent contact information is not available, or if the lien agent is appointed? So what happens? Then that's when the old law applies. So if the lien agent contact information is not available, or if there's not one, then old law applies. And before we get a little bit deeper into the lien agent statute, I want to remind you one thing. The lien agent statute really only protects the title insurance companies, and that's it. I'm trying not to call out people's names, but there's a good friend of mine who is on this webinar today who I've known for years, and one day she asked me, she said, James, why in the world, what does this do for us? What does this statute, that is the lien agent statute, do for us? And I told her, not a thing. It really protects, it's designed to, and it's supposed to protect the title insurance company. But the way it was couched was, and the way it got passed at the legislature, was that we want you to do this so we know you're on the job, not that they don't already know that you're there, but they know you're on the job, and in that way they know who they're supposed to go after to see if you've been paid or not paid, get a lien waiver. That's the design. The real purpose of it, though, is to give title insurance companies a cleaner opportunity to issue title insurance company and have lower risk. So the law says if we on a particular project, if there is a lien agent appointed and you've not given notice to the lien agent, and then the project sells to a new owner, your lien rights have been cut off. Can't do anything about it. So that's how it's protected the title insurance company's risk, so they now can have title insurance on that project and not have any claims or have fewer claims. So that's sort of hopefully that helps you think through that. There's a reminder that obviously notice to the lien agent does not replace the need to file the lien on the real property or a lien on funds. So some people I know initially said, hey, look, this is great because I can do this and not have to lien it. Absolutely not. If you do the notice to the lien agent, it gives you the right and the opportunity to then file a lien if you need to, but it does not take the place of it. And I know some of the subcontractors have gotten, or I think initially got really upset. They thought you were liening the job when you gave this notice. This is not a lien. This is just putting your foot in the door saying, hey, I'm on the job. I think I've even heard some this year, people saying that their customers are getting upset when you do this. I'm going to tell you, if you don't do it, you have an opportunity of losing any lien rights you could have had. So I would encourage you to do it. So again, you still have to do your lien if you haven't been paid within 120 days of your last furnishing of materials in order to preserve your lien rights. So you still must serve the lien. For example, if you're going to do a lien on funds, you still have to serve that on all the people involved. And again, to remind you, there's really two types of liens in North Carolina. One is there's a lien on the real property on the dirt, which again is helpful if you are a first, second, or third tier. And even if you've actually contracted with the owner, it helps to make sure that you have some security and collateral if you need it, number one. But a lien on funds, you really want to get paid. That's what we're going after, is trying to get money. The lien on funds is the second type of lien in North Carolina that preserves, if you can, once you serve that, once you send it out by certified mail, return receipt requested, anybody that owes money in that chain is an obligor, at that point, that's when they're supposed to hold the money and say, okay, this is how much I owe to the tier below me. And that's what you're trying to preserve and capture. So the other aspect of preserving your lien rights is called the notice of subcontract. So for example, if a contractor files and posts a notice of contract for a particular job, you as a subcontractor are supposed to then send out a notice of subcontract to the general contractor and owner, which again says, I'm on the job. Now you think, wait a minute, didn't I just do that with the notice to the lien agent? Yeah, pretty much, except that the law provides for both. The notice of subcontract and the notice of contract was designed and put in place by the AGC. And the reason they did that was they were trying to, again, cut off lien rights for people below the contractor. And so they said, if we do a notice of contract as a general contractor, then any subs below us should serve a notice of subcontract. You don't file it anywhere, you don't post it anywhere, you send it to, for example, the general contractor and the owner, or anyone in between you and the general contractor. So again, there's two aspects you got to do to preserve your lien rights. Let's look at the lien agent just for a moment. That is an agent of the owner, and it's appointed or by someone to receive the specified notices. That's their primary job, is just to receive. There is no financial obligation by the lien agent. They don't owe anybody an obligation other than to receive the specified notices. The law says they got to be affiliated with a title insurance company, and they've got to be listed on the Department of Insurance website and so forth. Typically, it's paid by the owner. Sometimes the general contractor might actually pay for it, but again, I'm sure they're going to be billing the owner for it. The lien agent for the owner, obviously required to designate a lien agent no later than the time that the owner first contracts with any person to improve the real property. That's the time frame when the owner has to appoint the lien agent. To locate a lien agent, you can use the Department of Insurance website. You can also use Liens NC. The appointment of a lien agent before a building permit is issued or before signing of the contract by the contractor is when it's required. So again, if they pull a building permit, they're supposed to have already gotten a lien agent so they can then put that on the building permit. So a lot of times you'll see that connection. How else can you get a copy, or how do you get that information? You can write to the owner and ask for it. You can request. They got to provide it to you within 7 days. If they don't, then the lien claimant is not held responsible. That is, you can still go forward if they've not responded. I don't know if y'all have ever done that or not. I don't think many people have. A lot of people, I know they are really working hard on the Liens NC website to try to find it, or they may ask their customer if they find it. So the notice of the lien agent is supposed to be posted on the bulletin board at the job site. So I know a lot of y'all have gone to the job sites. There's a QR code that's supposed to be printed on the notices. You can take a picture of it. It'll actually take you right to the Liens NC website, and it'll give you the information you need. So those are the typical ways of doing that. But the lien agent contact information must be posted within the building permit or on the job site on the bulletin board. And they've got to be supposedly not hidden. So I know when this law first passed, we started looking at different jobs. We'd actually go to the job sites and look to see if they were posted. And it was amazing how often they did actually post them. I haven't done that in a while, but I presume that they're there for the most part. What about the lien agent for subcontractor supplier? To fully protect your lien rights, you are required to give the notice to the lien agent within 15 days of your first furnishing materials and supplies. Now, I know a lot of our clients, and some people are looking and go, well, I may not do it within the first 15 days, I'm going to do it within the first 30. So the law says in order to preserve your lien rights and to protect them, you need to do that within the first 15 days of furnishing materials. I've told some of you this story before. Nick Long, who is Used to practice law. Now he works for Lien's NC. Really great lawyer. Think the world of Nick. Really smart man. But he and I disagree. At least we used to disagree. I haven't talked to him about this in about a year or so. But he used to say, well, James, that's not really what the statute means or intends. I go, yeah, but Nick, I'm not going to tell my client that when the statute says 15 days, within the 15 days of first furnished materials, and they do it in 30, and we go to court, and we get hammered. I'm gonna look sort of silly. Can't do that. And he understood that, but he said that's not the intent of the statute. I said, well, that's what it was written. We also got a question today about the time frame within when to do the notice to the lien agent, but also more importantly, what's the time frame and certain minimum dollar amount that the jobs need to be before the lien agent, notice the lien agent is really important. And that's a great question. So, and what's the threshold that you would use when you would always do a notice to the lien agent? I know a lot of our customers have come up with, okay, if the job's under $3,000, we're not going to do a notice to the lien agent. If it's under $5,000, or they sort of pick the dollar figure. I think you've got to pick your threshold, and I would probably encourage you. If it's under $3,000, may not be necessary. If it's more than 3 or 4 or 5, that's sort of what I tell people. If the people ask me, hey, look, at what dollar amount does it really make a difference in filing a lien? My advice is about $3,000 and up is where it starts making sense. Sometimes if you've got, say, a multiple of liens for a particular neighborhood, and it's all in one neighborhood, maybe one general contractor, one sub, and it's maybe 5 houses in a row or something like that, and say it's $2,000, that might make sense. Again, maybe you look at the aggregate cost or dollars that you've got in those jobs. That might make a difference. But around 3 probably is a good ballpark. So we've got a little survey that we want to throw up. So you'll see this on your screen that we're going to throw up here. We would love to have you to respond to this. And it sort of helps y'all figure it out as well. So the question is, the process of giving notice to the lien agent has improved payment on construction projects. Your answers are either yes, no, or cannot determine. So if y'all would just help respond to that. Y'all are doing really good. So far we got about 40% voting here. And still see if we can beat the national average of presidential elections. We're at 61 now. Y'all are coming in well. Thank you so much for doing this. Hopefully this will help you as well. We'll give you about another 5 seconds to vote. We got about 83%, 89%. Man, y'all are doing awesome. Doing great. Thank you so much. Okay, we'll share the results here. So the results, oh wow, man. The process of giving notice to the agent has improved payment on construction projects. 19% say yes, 19% say no, and 63% say can't tell a difference. That's interesting. So thank you for doing that. That's really interesting. We just got another question in. It says, what dollar amount requires a lien agent to be appointed for a project? Is it still 20? No, it's $30,000 in North Carolina now. So $30,000 is where, if the original building permit is $30,000, that's when it's required. So thank you for that question. If y'all have other questions, please submit them. So that's interesting on the payment issue. And I agree with you. I don't know that, sometimes I'm not sure that we can tell. And we got another question earlier today, and I'm going to go ahead and address that while we're talking about this. This person sent a question and said, well, if you've done the process for the lien agent, you've given the notice. So at the closing, when there's a closing for the house or loan, then the attorneys are supposed to automatically notify me to sign a lien waiver before they do the closing, correct? And, if you look at the statute, that's what you would think would happen. That is, that they would definitely come to you and say, okay, you provided materials, we want to get a lien waiver from you. That's happening so few times. And again, I'm talking to our clients, and I'm getting that information. Sometimes it happens, but very few times can we tell that it's actually happening. When this statute first came out, I think there was, without a doubt, there was a lot of that where the closing attorney would say, okay, to the lien agent, send me all of the notices to the lien agent. And they did that, and then they started following up with the lien claimants. And I think what's happening now is they're going to the builder and getting a final lien waiver from the builder. And those lien waivers have changed, because it used to say that the builder, the person signing the affidavit says, hey, look, I've already paid everybody. That's taken out. They don't even use that part most of the time now. But they've changed the wording so that they're not putting that builder in jeopardy, but they're saying, hey, look, this is a final waiver, and basically still cut your feet out. Because you would think the lien agent statute would be protective of you if you've done your lien agent, notice to the lien agent. But as I said earlier, remember, notice to the lien agent is not a lien. So if you've given your notice to the lien agent, and let's say you've done your notice of subcontract, but you're at the job site and it's getting ready to close, they still could close without getting you paid and not ever contacting you. Again, if you've given your notice, at that point, if you've given your lien agent notice, subcontract notice, and you filed your lien, then they've got to deal with you before they do the closing. That's a real stinker having to do with the statute, but that's the way it's written, and it's not. You wouldn't think that, because when you think about how it's written, but they have no obligation to contact you unless you've actually filed a lien. So the duties of the lien agent is to collect information, all the notices to the lien agent, and to provide the closing attorney who has made those requests for notices. So that's all they're required to do. The purpose, we talked about it, it's really just to hold a repository of the pre-notices, that is the notice to the lien agent. And that's it. That's really all they do. What about a contractor? You can locate the lien agent contact information in bunch of different ways. You can look at the building permit. You can get it in contract with the owner. Sometimes the owner will have a contract. And if you see the owner's contract with the contractor, you'll see it there. The inspections office has it. There's a notice from the owner you can get, or you can go to the Liens NC website and get it as well. The contractor is actually obligated by statute to pass along the lien agent information to their subs, and the sub is actually, if you're a supplier, is also required to pass it to a supplier. And sometimes they do and sometimes they don't. Failure to pass it along, that is, pass along the notice of contract information, makes the contractor liable for actual damages. Now, when we saw this, we're like, yes, that's going to be a good provision for our clients. Interesting enough, there's been no cases so far by that, so I'm not real sure if that's going to ever work out or not. We obviously don't want our clients to get hurt financially, but we just know when there's jobs, there are going to be times when you're going to want that information, try to get it, and you can't get it. By definition, a potential lien claimant is anyone who has the potential to file a lien on real property that's being improved. So if you've provided materials or labor for a particular job, you are defined as a potential lien claimant. That can be a first, second, or third tier sub or supplier. Again, that's more of a definition standpoint. The statute also addressed if you do on-site performance or either off-site performance. So a subcontractor or supplier who does not perform at the job site, that is, they do nothing on the job site at all. And that includes deliveries to the site as performance. So they do all their work somewhere else. If the contractor or a higher tier sub should provide the lien claimant with contact information, but if they fail to do so, then the potential lien claimant must make a written request to the owner for the information. So if you're a sub and you never ever touch the project, you make them, I'm just going to say you make the material somewhere else and you ship it to your subcontractor, you actually never deliver it to the job site, but your sub does, then you are a subcontractor who is performing off-site, and they're supposed to, again, still give you that information. And you've potentially got a claim against them if they don't provide that. Again, I don't know how that applies to many of you, but it could to some. That the owner must also provide the lien agent information within 7 days of receiving the request. If they don't do it, then they could be held responsible for any damages. Again, I don't know many of people that are contacting the owner. Excuse me. I don't know many people that are contacting the owner to get the information. A lot of times I know y'all are just reaching through the chain, your customer to the general contractor, or looking on the Lien's NC website. That's generally the easiest way to do it. So penalty, we've talked about a little bit. If the owner fails to provide, then the old law applies. That is, then you're not required to do that. And even if they sell the property and you haven't given a lien yet, you could still lien the project. We just recently had this for a client of ours where they helped very early stages of a neighborhood. It was like really, really, really early stages when they were just clearing the land, so forth, doing the subgrade, the subsurface type work. And interesting enough, they didn't have a building permit issued, so there was no lien agent appointed. So the question is, what do you do? Old law applies. You still have the rights to do liens. In fact, we filed those liens this week. And hopefully, we've talked to the general contractors involved. It's a fairly large project. They're going to make sure that our customer gets paid, our client gets paid, which is the great part about that. But again, if there's not one appointed, then you don't have to do that. That is, if the lien agent is not appointed, you don't actually have to do that. So let's do this one. We've got another poll for you. We're going to roll that out now. If you'll take a look at your screen, the question is, how often are you contacted once you have given notice to the lien agent before a project is closed? That is, you've given the notice to the lien agent. How often are you contacted before it's closed to find out whether you paid or not? So are you contacted often, seldom, or almost never? So if you can answer that question, y'all doing great. Got almost 60%. Y'all are doing a great job. Thank you so much. I hope these polls help you. They help us just sort of understanding what's going on. We'll wait just a few more seconds for a few of you to finish voting. Okay, let's close it, and then we'll show you the results. How often are you contacted? Very much like we were thinking. Sometimes 8%, or often 8%, seldom 62%, almost never 31%. So that's really interesting stats. It sort of almost goes in concert with what we're hearing from our clients. So I wish I could tell you that it was going to be different, but I don't. They're not doing it. I think the title insurance companies and the closing attorneys are realizing it was so much work to reach out to everybody. They just finally went back to the contractor and said, "We're going to do a straight up lien waiver to avoid that." So that's hopefully that's helpful to you. Okay. What about searching the Lien's NC website? We've talked to them a bunch of different times. A lot of this information actually comes from them to help you understand how to do the searches to be more effective. To identify the property, remember that the Lien's NC website is a database that's based on property identification, not the owner. So they're keyed in on the property identification. So also think about this, no one's really monitoring what information is being placed in the database. They're not sitting there looking at each one for accuracy of the content, okay? So under the entry number, there's an express pass. You can maybe more than one entry number. So sometimes you got to if you know the entry number, your job is really, really easy from there, obviously. If you know the owner or contractor, that sometimes is more helpful. So we will look at some of these. So under the entry number, if you know that, obviously you can enter that information. The advanced search, I'll be honest, because a lot of times y'all will, we'll get calls from a lot of you to say I can't find it. I just immediately go to the advanced search. You can look for property address that way, or other legal description. But you also got to think about this. You've got to think about how they listed it on basically the permit, the building permit, because the Lien's NC comes first, then the building permit. So sometimes those things go hand in hand because they're thinking the same thing. But it's really based upon what they put down when they put the information in there. Other distinctive keywords, like for example, if there's a really unusual word for an owner or a contractor, that's helpful. I'll tell you another time, other ways I've done this under the advanced search. I know, for example, I'm looking for a particular job and I just can't find it, but I know, for example, that another supplier is on that job. I'll actually go in and put the supplier's name in and narrow it down from their list, and then look at see how they found it. So a lot of times I've done it that way and been lucky. This again comes from NC website, the NC Lien's website. Their suggestion is keep the search simple. There are no wild cards available. That is, you just can't enter the first 3 letters of a word or name and it pops up. You can do an owner name. Try the last name only. Try to avoid the initials, DR, D.R, things like that. Address. Just try the road name. Avoid the street, avenue, drive, highway, so forth. Do not use abbreviated or variable words, and keep search period dates broad. That's the information that we've gotten from Lien's NC. We just got another question. Let's look at that real quick. It says, we are trying to identify a job site and street address would not work on the entry number anywhere to be found, so the salesman was calling at the job site from his GPS-enabled phone, so he found it through the GPS location. Wow, sweet. That's a great way of doing that. I hadn't even thought about doing that. And again, if you can't find the job information sheet on the board, then that's another way of doing it. That's great. Another comment. Let's see. And just a comment: if you file your notice to the lien agent on the website, it's very helpful in getting paid, as it shows you means business. Well, that's a good point. So thank you so much for sharing that. So again, looking at the appointment of the lien agent, advanced search, you can put in keywords, you can put in dates, as filing dates to or from when you think they created it. Again, I have looked for, pulte obviously is an unusual word, but it's also going to come up with a lot of results. This is one, again, that's an example from, I think, a couple of years ago we did. Obviously, looking for 22 or 2,256, way too many. You can't do it, so you got to narrow it down and try to figure out how to do it. So you can put in Pulte and Charlotte, or you can the other towns. Probably still going to be a lot, but you can try to narrow it down from there. This one we did Pulte, Charlotte, and Garden Webb, and that's going to obviously narrow down the search a lot more. So only 6 times. This actually came from their website, that is the Lien's NC website. I put the arrows beside the ones that I have found most helpful. So, for example, search for the most unique words or phrases from the project information you have. That's what a lot of times I look for the most unusual words, not the street, not the street identifier, but sometimes if it's unusual street name, unusual general contractor. D.R. Horton, I wouldn't suggest. That's a hard one because there's going to be so many. But those kinds, but look for number 4, for example, place multiple words in quotation marks to search for an exact phrase. We've done that a lot of times, and it's just going to look for those words when it's in quotation marks. Very, very helpful. The connecting word "and" you got to put it in all caps. We'll search for the keyword phrases in that query. So, for example, in all caps, let's just say you're going to do, I don't know, just think about a word and then the word "and" another word in quotations. It's just going to look for those 2 words in the search. So again, we have been very, very fortunate using that tip. And then the number 7, when they're connecting words not in all caps, it will eliminate a keyword or phrase from the query. So, for example, you're putting one in, all of a sudden you realize you're getting, I'm just going to use D.R. Horton. You can say, not in all caps, and in quotations, D.R. Horton. So hopefully it would eliminate all of those. Hopefully that makes sense, but those 4 out of those 10 make a big difference, I think, based off of what we've looked at over the years. So as a potential lien claimant, what are the requirements? You must complete the notice to lien agent and submit a lien agent via one of 7 ways. Most people do it by notice to on the website, which is the most primary way of doing it. You can do it certified mail, all these other ways, but most people are doing it on the website, which makes sense. What's the time frame? You're supposed to do it within 15 days of beginning your providing materials or work on the job. So that's what the statute says. Let's just say you're 16, 20, or 30 days or 45 days and you still haven't given notice. What do? Still go ahead and give your notice to the lien agent. Doesn't matter if you're that much later. You may not be able to claim the priority time that you missed, but you might be able to claim certainly from that point forward. So if you haven't done it, go ahead and do it. This is just talks about the time again if you're on the job or off the job. In all instances, the notices must occur before the date of recording of a deed of trust or the selling of the property to another buyer, another owner. Early is always best. The example I told you a minute ago where we just did some liens on this subdivision, the developer had already sold some of those lots, and so that excluded the opportunity for us to be able to capture those, and because they'd already sold them. But we're going to claim rest of the property, and we have a lot of common area maintenance, common areas that are touching all of the other lots. So that, I think, preserved our rights to be able to claim a lien on all of the neighborhood, but it'll always be interesting to see what happens. But again, always, if you do it early, you're a whole lot better off. The purpose we've talked about is trying to create a reliable record for looking at the real estate. They're trying to protect their investment, if you will. If a notice to the lien agent is served and a lien on real property is filed, asserted prior to the real estate closing, then lien has priority over any other later buyer of that property. So that's what you're trying to get your foot in the door and stop that sale, make sure that you get paid. So we've talked a little bit about the notice to the lien agent and lien on funds. There's little impact to a lien upon funds or lien on funds when a notice to the lien agent is given, because the lien upon funds does not impact the real property. The lien notice to the the notice to the lien agent is really only looking at the real property. So let's say, for example, that you find out the property is already sold. When you finally think, oh, I need to do a notice to the lien agent, and you realize the property sold, you still could do a lien on funds if there's any money in that chain that is owed, say from the owner, general contractor, or your customer, wherever you may fall in there. If there's still money owed, let's say your customer says, look, I haven't been paid on the project, do a lien on funds, doesn't matter. Many of you know this. I'm going to remind you. There is no statutory time frame that creates a deadline on when you must file a notice of lien on funds. So, for example, it could be 6 months after you've been on the job site. If they're still owed money, you still could do a lien on funds. So hopefully that helps. If you're confused about that, let me know. I'll be glad to go back over that with you. If there is an inaccuracy in the description of the property, the good news is the statute says you can go back and correct that, having to do with a lien agent notice. Again, other changes, the dates of first or last performance allows a subcontractor to use either the first or last dates of performance of the contractor if you're dealing with if you're a sub. There hadn't been a total new change to that, but it's something that you could possibly use. We've talked about the notice of contracts still being applicable. The owner or the contractor, within 30 days of the building permit being issued, is supposed to file and post a notice of contract if they want to use that provision of the law. I know a lot of general contractors that do this to try to cut the feet off of subs and suppliers. I've even heard this year, and it blew my mind. General contractor filed and posted the notice of contract. The GC supposedly told their subs, do not file a notice of subcontract. Now, I'm going to tell you, that is just wrong, because they basically were saying, we don't want you to be able to file liens down the road. That is just a bad general contractor that trying to give that. They were trying to strong arm their subs. Not a good idea. If a notice of contract is filed, a sub or supplier should complete and serve the notice of subcontract. And I'm going to go ahead and mention this. If you don't know what that is or don't have the form or you want the form, please call me or email me. I'll be glad to help you with that and show you how to do it and talk with you about it offline. Lien waivers, we know you get a lot of lien waivers. If you ever have a question on a lien waiver, please let us know. We'd be glad to help you. We read tons of these every week. And, you know, I've said this before. I know a lot of y'all have heard this. This basically is word processing. Some people say, well, that's just our form. We can't change it. Yeah, you can. It's word processing. You can change it. So if it doesn't match the facts of your circumstances, please don't sign it. One of the questions we just got in on notice of subcontract was, are you saying we should do notice of subcontract and notice to lien on funds in the beginning of the job? Now, I did say what we do need to do is a notice of subcontract. If you are worried about payment at all, go ahead and do lien on funds. I mean, you may not want to do that quickly, but certainly a notice of subcontract. And if you are starting to get some kind of eerie feeling that the project's going to close or for some reason you're not going to get paid, you could do a lien on funds pretty quickly. You don't actually file it. You just send it to the owner, GC, sub ahead of you. That preserves any of the funds that are in that chain. So it captures that. But certainly do the notice of subcontract early. And then the question is, can we get a copy of the PowerPoint presentation? Absolutely. We'll email it out this afternoon. I'm looking at Michael as I say that. Go, right, Michael? Yeah, we can send that out to you. We'll email it out to you. So back to the waiver of subrogation lien rights. If a contractor signs a waiver of lien rights with the owner, and you haven't done anything as far as filing a lien or no one's filed a lien, it takes out everybody. If you have filed a lien, they cannot do that. So be mindful of that. I still think that is unconstitutional because our Constitution of North Carolina says that everybody who provides materials or labor to a construction project has lien rights. I think someone else being able to waive your lien rights is absolutely unconstitutional. We unfortunately have not ever had the ability to take that case to the Supreme Court of North Carolina. I hope I'll be able to do that one day and change that law because I just think it's unfair. So again, think about the waivers. If you look at a waiver and it does not match the facts of your situation, please don't sign it because it's going to get you in trouble down the road. You may wind up having to explain why you signed that. Signing a false lien waiver constitutes deceit and misconduct. And general contractor, this was one of the changes they made. It's could become a disciplinary action with the licensing boards. I know some of you that are on the webinar today, you have a general contractor's license. So if y'all are signing lien waivers that are not right, this could impact your general contractor's license, so be careful with that. False lien waivers also are a criminal misdemeanor. We used to have a lot of issues with the lien waivers, and I'll be honest, we really haven't seen that many in the last couple of years, and I think primarily the reason why is that the title insurance companies have changed the forms, and they've taken out the sentence or two where it says that I know of no lien claim, and it also it took out the provision that says I paid everybody below me, or that I paid all subs and suppliers. By taking that out, they've really taken out the sting of it being a false lien waiver. So again, please make sure that you're not signing false lien waivers. Let's look at a few cases recently and then a piece of legislation to pass this summer. One of the recent cases that came out is Blanton Suppliers versus William Barber. The real gist of this case is that there's a critical time for determining whether an amount is owed for purposes of a lien statute, and when the obligor, again we talked about that in the very beginning, receives the notice of lien. In this case, Blanton filed a lien against the project, and William Barber was the general contractor, and there was an owner. When they filed the lien and the notice of lien on funds, they were owed, I think it was like $14,000. The lien was like $27,000. And so there was like 14 owing from the owner to William Barber. And the court said the critical time for determining that is when you send out the notice to lien on funds. And they said the notice of lien looks to whether a sum of money is owed to the contractor or subcontractor at the specific point that the notice is received. So what they said was basically, hey, the $14,000 that was owed, that should be paid to Blanton. But that doesn't mean William Barber doesn't owe the rest of the money between the 14 and the 27. That you're saying the lien claim, the owner should have paid Blanton that $14,000. And that was a recent case that came out. Let me see, I think I fast forwarded. No, okay. Another case that came out, and we were involved in this case, and I'm going to tell you, this case still gives me heartburn because I still think there was some funny business going on between the general contractor and the owner. There was a dispute between the owner and the GC. The owner contends that they owed no funds to the GC and fired him, kicked him off the project. There were, when I say multiple lien claimants, it was a ton of lien claimants. Suppliers, subs, it was everybody you could imagine. The court said that lien claimants of suppliers or subs, when they exist, if at all, by subrogation to the payment rights of the contractor in privity with the owner. And what had happened was the owner was getting the general contractor to sign the lien waivers every time they made a payment to him, cutting everybody else's feet off. So a lot of people filed liens, but they were saying, oh, I got a lien waiver from the GC that took everybody out from this point forward. It really was, this case, I mean, I can't tell you probably the millions of dollars between suppliers and subs that didn't get paid because of what happened. Every time I pass this building, it's right up the street from our office, I think about this, and it just bothers me to no end because there were a lot of people that lost a lot of money, and the owner, I think, laughed all the way to the bank, I'm not sure. The key takeaway of this is timing is important. When you gut feel something's going on a job, start making those phone calls, follow up, and file those liens as quick as you can. That's the takeaway I've got from that. One other piece of legislation passed this summer, and it has to do with the lien agents. And we fought this. Unfortunately, we were not successful with it. But it says this, for real property subject to the lien agent statute, so if there's a lien agent statute, if this applies, $30,000 and above, it says a potential lien claimant may cancel a notice to the lien agent by using the Liens NC website, okay? And it says for real property consisting of one or two family dwellings, a potential lien claimant shall, that is a must, that's the legal term for must, it says shall, cancel the lien notice to the lien agent by using the Liens NC website. We were able to fight to get these words in within a reasonable time after the potential lien claimant has confirmed its receipt of final payment for the improvement. They had this thing initially chock full of, I thought, some pretty significant milestones for you as a potential lien claimant to cancel your notice. And we were like, no, we've already given notice. All this is doing the work of the title insurance company. That's all this is for. But they said we were able to get this changed, and I'm telling you, I don't like to bet, but I bet you $100 that it won't be long, and they're going to come back and they're going to change this to make it mandatory, and there's going to be teeth in there if you don't. Right now, there's no teeth. There's nothing. If you don't do it, there's no foul. There's nothing in statute that says you're liable for anything if you don't do this. So again, the effective date of this is October 1 of 2018. So not this year, it's October 1 of next year. So this doesn't go into effect until next year. So again, if you have given notice to a lien agent, and again, I think this goes into effect after October 1, then you may cancel the lien agent notice. If it's on a one or two family dwelling unit, then you shall, and that's within a reasonable time period of being able to confirm that you've received final payment for the improvement. We tried to make it as broad as we could, and that's the best we got. So hopefully that helps. Right now, there's no teeth. If you just say, you know what, not going to do it, that's okay. I don't think it's going to bite you. Could you get sued for it? Yeah. I mean, you get sued because you're looking at a computer screen right now, but they're not going to be successful. I don't think they're going to be successful because there's no teeth in the statute as of now. Hopefully that doesn't change. So there was another case which we talked about last year. The real interesting thing about this case was that the names on the contract to buy the land and the name that our customer had, our client had on their account with a builder, the general contractor, was not exactly the same. In fact, the builder's name on the contract to buy the property was like an abbreviation, and so the bank was trying to say that our client, the general contractor with whom our client dealt with, did not have an interest in the real property. That's totally ludicrous, but thankfully we won. And the supplier won, but we got 100% of that, which I was really thankful for them. But it was a long fought battle. And then there was another case where the attorney's fees were granted to a homeowner against the builder, where the builder filed a lien in a lawsuit. The real boiling it down was that the court awarded the attorney's fees. They said the party knew that they had an unreasonable refusal to resolve the case. The statute says this, that there's a couple of ways of getting attorney's fees in this situation. One is if it's in your contract. Many of you have that in your credit terms, that you can recover attorney's fees. Typically, that's going to be 15% of the balance due and owing. Or you can recover it under the lien law statute. And I'm going to beg you, please don't rely on that statute, and I'll tell you why in just a minute. But that statute says you have to be a winning party to get your attorney's fees, which means you get 51% of or greater than what you claimed. So if you just claimed $1,000, you got to be able to get $501 to be able to get attorney's fees. And there has to be an unreasonable refusal on the other side not to settle. So there's a two-pronged test. You got to get 50% or more, and there's got to be unreasonable refusal on the other side. And the reason I say please don't rely on this, I've heard more than one judge say, well, you did get more than 50% of what you claimed, but I think the other side had a reasonable excuse not to pay. And you sit there and you think, what? So please don't rely on that statute. It's just way too easy to have it in your contract to ask for attorney's fees. So make sure you do that. We've got, I think, one more poll question we'd love to get your impact on, your thoughts on. And that's coming up. It says, webinars like this one are helpful to me. So yes, no, or no clue. So if you would vote for that, tell us which one. Webinars like this one are helpful to me. Man, y'all are quick. All right, I'm going to give you a few more seconds, and then we'll close it out. All right, we'll close it out and show that result, and let's see what it says. Got too many screens open. Sweet, 100%, yes. All right, if you ever have suggestions how we can make these better, please let me know, because we want to we do these for you to make it hopefully help you. A couple of the cases which we've talked about before, I'm just going to remind you of those. Brown's Building Supply was a case where it was a fight about a general contractor's license not being required. I know, for example, a lot of you are putting in cabinets or pick your product, and our client is a supplier. They dealt, and also an installer. They dealt with a homeowner, and the amount of dollars obviously was pretty extensive what they were doing, and they hadn't paid him in full. And they said, well, we're not going to pay you because we think you're not a general contractor, and you should have been a general contractor, and the dollar amounts exceed what the statute provides where a general contractor's license is required. That was totally not following the statute, but we weren't sure what the court was going to do. The court said the degree of control to be exercised by the contractor over the construction of the entire project was key, and thankfully our client won. So that's one of those cases that I was afraid was going to go the other way. Not that I thought it was bad, we had bad law or bad facts, but you just never know. and the other one's about attorney's fees as well. So just make sure you got that. So if you've got other questions, you please feel free to submit those. We've got one here. It says, can a lien waiver be signed with electronic signature? Man, that's an awesome question, as all of them have been. But yes, a lien waiver can be signed electronically, and it's valid. So that's a great question. Thank you for that. Let me see. There's one more. It says, for all those involved in either solar installation or fiber optics, as the land is not owned by, that's a good one, not owned by the solar company, and the right of way for cable installations also, so we always go for lien on funds. So let me go back and say that again, because that's a great point. This has to do with solar installation or fiber optics. It's very similar to cell towers. Cell towers folks and people that are doing the solar installation generally don't own the property. They have a right to install it. But for those involved, the solar installation or the fiber optics, the land is not owned by those companies. They generally have a lease or they have an easement to put that in there, or right of way. So doing the lien on funds is a great way to capture those funds. So that's a great point. Thank you so much for sharing that. All right, we beat this horse pretty well today. I hope this is helpful to y'all. Please, if you haven't connected with us online, we would love for you to do that. Trying to put out information that's helpful to you. And if you've got questions or thoughts or comments that you can share with us that we would improve, please let us know. Thank you so much, and hopefully we'll be back in touch with you guys on November 16th. Have a great day.